Well, I'm really happy. I'm Kim Watterson. I'm a partner here in the Los Angeles office, and I'm the practice group leader for the appellate group. And I'm really happy, and I'll explain why in a minute. I really just get to be the MC for this program. When Ann was putting it together, she said clients have expressed an interest in data privacy topics, and in particular, perhaps the new California statute. And like a good appellate lawyer, I said, well, I can figure that out, because what I do for a living is take a bunch of new material, figure it out, and stand in front of a court and talk about it. And I do work on data privacy matters, but again, when the matters get to litigation, not in terms of advising clients with respect to compliance and other issues. So I was delighted when my partner, and I'm going to let her pronounce her own name because she'll do it correctly.
You said it great. My name is Xiaoyan Zhang,
who is a data privacy specialist in our San Francisco office, when she offered to come down here and help with this program. I'm not going to have much to say. She's the expert. Occasionally when we're talking about potential litigation issues, I may pipe in and have something to say. But we are on a new, is it a new horizon here in California with the new statute not yet effective?
Very much.
All right.
Thank you, Ken. So, good afternoon, everyone. We're going to spend the next an hour together, talk about this very exciting yet controversial statute, CCPA. So, do a little poll here. How many of you actually heard about CCPA before? Wow, very sophisticated crowd. How many of you actually are privacy lawyer? Wow, 3, 4.
I wear a privacy hat, but I wear a lot of hats.
Great. So this session gonna be privacy or CCPA 101 for privacy lawyers who probably have been to a couple of seminars before. You have to bear with me, or spend the time to think about what you're gonna have for dinner. But just in general, if there's one thing you need to know about CCPA is what? Like in a layman's term, CCPA is kind of like the GDPR in the US. Everybody knows about GDPR, right? Like May 2018, everybody as a user, you probably have received an email notifying you that somebody has been updating their privacy policy, right? More than 1, 2, 3. Now, this is a big picture. In the US, we do not have a comprehensive data protection law on the federal level, national level, all right? Some sectors, some industries, like finance or healthcare, they have some statutes specifically governing them, either be GLBA or HIPAA, but other sectors do not, are not subject to those laws. Now, on the state level, before CCPA, there are only being state laws governing data breach notifications, meaning if you have a data breach and you reach a certain statutory threshold, then you are obliged under that state law to notify your customers, right? Some of you probably have received some such letters from your vendors. Now, CCPA is the first state privacy law, comprehensive privacy law in the US. California is the first. And it has a lot of similarities to GDPR, but not quite the same. So for non-layman's purpose, you can think about just CCPA as the GDPR in the US. Now, this is the topical overview. We're going to go through all of that in 1 hour. First, the timeline and the related California Attorney General rulemaking. So, CCPA timeline enacted in June 2018. What happened in May 2018?
GDPR.
Yeah, GDPR went effective. So think about the timing. What inspired CCPA? Now, I mentioned controversial, right? What's controversial about the CCPA? Partially because it was drafted and adopted over a short period of time. So what happened when you do things within a time crunch? Everybody's laughing. So original effective date was for January 2020. That's a very kind of a good number, and you have 1 year to think about it and to prepare for it. And then the amendment is still coming along the way. Okay, there was one major amendment came August last year, sort of revised some of the provisions in a quite drastic manner, and there are more yet to come. So, in terms of CCPA for planning compliance purpose, you need to kind of prepare your mental mindset. Do not try to find answers to everything because you will not be able to, okay? No one can give you that. You need to, pay attention to all the updates, know what the general requirements are, and then what generally you need to do in the time being. Now, their enforcement deadline, right? Everybody's know, January 1st, 2020, what does that mean? The amendments in August I mentioned last year, they changed to the effective date a little bit. Now, the AG enforcement the effective date will be either July 2020 or 6 months after passing the statute, whichever is later. So essentially you have a 6 months grace period, right, to kind of get yourself ready. Now, right, it said, why is Attorney General involved? Well, because it's a state statute and AG wants to get involved. So there's a process, actually. They can gather your input on a list of things here. For example, definition categories of personal information, definition of unique identifiers, and some other things. So far, AG has held a couple of open meetings where public, lobbyists can walk in and kind of present their complaints, most of the time, pontifications, and gather feedback and, to go back to do more revisions. Now, this is the top question, preliminary question. Does CCPA apply to me? Unfortunately, it's not a 5-minute analysis. It is more than I won't give you an estimate, but this is the general goals of the Act. You don't need to read it. The Act literally summarizes what the statute about. Basically, one line of summary about the CCPA is the second paragraph. Companies are barred from collecting categories of personal information other than have specified in the disclosures, and also barred from using personal information for additional purpose unless consumer has been notified. It sounds simple, but this is just on the surface. So CCPA applies to covered entities. Those are the factors. Collect consumers' personal information, or on whose behalf such information is collected. What does it mean? You don't collect yourself, but you ask somebody else collect for you, right? Alone or joining with others, determine the purpose and the means of the processing of a consumer's personal information. What that language is coming from. Smells like GDPR, right? Determines purpose and the means, meaning you actually have control to how the data going to be processed. And then third, most importantly, does business in California and meets one of the more of the following threshold. Number one, has annual gross revenues in excess of $25 million US. And number two, alone or in combination share for commercial purpose, personal information of 50,000 more consumers, and or derive 50% more revenue from selling such information. There are a lot of questions here, right? What is the 25 million revenue? Is it national, global, or California? We don't know. But think about if it's a national, say global revenue, right? But then the company only makes $1 in California. Is it fair for them to be subject to the CCPA? Probably not. And then right, and then here controversy surrounds like what does it mean? Does business in California? If I'm a business incorporated and have a physical presence outside California, but somehow I do serve consumers in California, do I qualify as do business in China? In California. I talked about China cybersecurity law a lot. This kind of like, in my brain now. So the answer to that question is yes. All right, you don't need to be physically present in California to be subject to CCPA, kind of similar to GDPR, right? If you're totally a 100% U.S. company, but you sell stuff to EU residents, then you are subject to the GDPR. Now, continued. I already said that territorial scope and collect the data. Right. We already covered that. Also covered. It's the statute is not just that simple. CCPA also applies to entities that are controlled by a CCPA regulated business that shares common branding. Okay. If you have a parent that you share the same brand, even though you're not covered, but your parent is covered, then you're covered. And also, the second bullet point is important for you to know. Entities that are not directly covered by CCPA, but who act as service providers to covered businesses, then those service providers gonna be deemed covered. Does that register? Not yet, but we're gonna talk about that more a little bit later, okay? So we talk about what entity are governed by the statute, right? Next, we talk about what consumer personal information are under. Now, personal information, we heard that a lot. Normally, it's tied to what a natural person, right? Does business have personal information? No. That's business information. It's not a natural person, so it's not a personal information. Now, CCPA's personal information, the definition is broad. It's broader than any of the other kind of state law, data breach notification law, right? Definitions there. It's even broader than the personal data definition in the GDPR. That's why a lot of criticisms or complaints are aiming at. So this is a personal information definition. Normally you would say, well, identifiable or identifies a natural person, right? Here, the language has what? Relates to, describes, capable of being associated with, and could reasonably be linked. That, under a lawyer's interpretation capability, it could literally cover everything under the sun, right? Your browsing history, sales information, even it's not specifically identifiable to you, but it can be linked to you, it can describe you, so therefore it could be considered a PI.
Before you move on, can I ask a question about of natural persons, but I'm focusing on the living in California? I want to come up with a hypo using myself. 2 years ago, I lived in California for just a year. Then I moved back to Pennsylvania. Let's assume my yoga studio is covered by the new act, and let's assume the act was in place. If I'm not living in California, but my yoga studio, because I didn't want to lose my membership there, continues to collect personal information about me, is that studio, for instance, exempt from providing me, who's not living in California, with notices or complying with the act when it comes to my personal information?
Well, this is a very granular question. Like GDPR, it has that too, right? Like, oh, I'm a EU resident, but now I'm, on the 2 weeks vacation in California, am I EU resident? Or I'm, seconded to U.S. office for 3 months, am I still a EU resident for GDPR purpose? Well, for this stage of the statutes, we don't know, okay? The statute says in natural person living in California, if you did not submit to, say, your resident status, whether, it's going to be rise to the kind of jurisdictional level, domicile, you're going to intend to make where you...
And the reason why I asked was I'm thinking down the road of when any one of you or all of us are faced with potential, we know the plaintiff's bar loves the nationwide class action.
Right.
And looking at, whether or not any litigation with respect to this statute might end up being narrowed to a class of folks, because we think about companies that are national companies and collect the same sort of information all over the country with respect to folks in all 50 states, as well as the territories, are the only plaintiffs with a potential cause of action those who are California residents.
Right. So I'm telling you, like, practical implementation for practical purpose, a lot of, companies dealing with the GDPR issues, they do not want to kind of track when you residents are, spending 2 weeks in U.S., 2 weeks in China. They're just going to say, we're going to treat you as EU resident, I'm going to use the highest bar. For here, it probably makes sense for companies to just use the California, the highest, the most strict law, versus like if you move to, Pennsylvania for 6 months, oh, I'm going to use the Pennsylvania state law, on you, because it's just a lot of work for 50-something states. Good question, though. Now, a big question, so we talked about consumer, right? This is whole about California consumers. So are employees considered consumers? Huh? They sound like two different terms, right? Like, how can consumers be employees? Now, it's not clear in the statute, but based on the definition, personal information, it could potentially include employment data. And also, there has been a precedent from Federal Trade Commission that to interpret consumer to cover employees. Therefore, we predict, based on the plain text right now, the consumer actually going to include employees. So there are a lot of scholarly articles written on that, like, oh, how horrible that would be because, this and that, a lot of implications if you had to treat employees the same way as you treat consumers for the reasons I am yet to discuss further. Now, CCPA bars sales information without opt-out. Okay, that's just one simplified way to describe the requirement. So we need to know what constitutes sales of information. You think, whoa, we never sell anything, we just share data, disclose, transfer data. Now, that's covered under the definition of CCPA sales. All right? So sales sales cover anything that's exchanged for monetary or other valuable consideration. You license data for a subscription fee, that's a sale, okay? And you license data in exchange to use somebody else's software, that's a sale because that's a consideration, non-monetary, even though there's some stuff it's not sale. For example, in a corporate transaction, you're selling, buying company's bankrupt, and you're just transferring data to the next entity. Ironically, that's not a sale, so be mindful of that. Now, this is probably, everybody should stretch their ears of potential penalties, okay? So, you're gonna be fined for 4% of your worldwide turnover. Did I get your attention? No, I'm kidding, that's GDPR, okay? Loosen up. I think if CCPA does that, it's probably going to be stricken under the Constitution, Commerce Law, lack of nexus, right? Can you find, non-California revenue? But let's walk through the penalties. Even for penalties, we don't know exactly what, penalties you're going to have. It does not define what's a violation, okay? It does not define like what damages under the statute means. So right now the implication is it might lead to dual or multiple enforcement stemming from the same occurrence. It's like double jeopardy here, the civil side. Now, administrative enforcement, we talked about AG earlier, right? AG is going to come into the picture. They're going to seek civil penalties for the failure to cure alleged violations after, there's a 30-day grace period. So for per violation, even though you don't know what that violation is, it's a $2,500 fine, and then, triple that for intentional violation. Of course, they always can issue injunctive relief order. Now, the Act also grants the private right of action. This is where Kim's passion going to be. So, but you need to be careful. The private course of action only concerns data breach. All right. What is data breach? When non-encrypted or non-redacted personal information has been, in a way, compromised because you do not have reasonable security measures, right? The key is reasonable, and then the key is non-encrypted and non-redacted personal information. So statutory damages are limited to $75. I thought that's a typo. $7,500, right? Per consumer per incident. Of course, then we don't exactly know what per incident means. And then, Kim, you have questions? No?
No, well, the one point I was going to put here, and I think lots of folks that deal with litigation with statutes that have statutory damages, of course, if someone can demonstrate, I asked today to make sure I was right about this, actual damages occurring, prove them up, put them on the board. Folks can recover, claims can recover actual damages as well as the statutory minimum. At least as it's drafted?
Yes. So I think, it's natural to know if you have actual harm, then you're going to be able to recover, right, if you can prove it. But if the consumer have not suffered harm, because privacy harm, sometimes it's very hard to prove, where you don't know that you actually suffering something, then you can recover statutory damage, and that's the limit here, okay? So sort of like an injury in fact type of rights, typical in the U.S. statute, but, it has been criticized by many scholars. Now, finally, well, not finally, next to the final, key requirements. So notice, we heard that a lot, right? The key column of privacy regulation is what? Give notice. You need to tell consumers what you collect. What kind of information you need to tell your consumers? Those are the categories. And you typically see in a privacy policy, right? Everybody now, every company has a privacy policy. You hire a privacy lawyer to review it. But now you need to have a sort of like a California section because, we're Californians. We have special rates. The other states don't have. And you need to do those specific disclosures that you probably don't have to be disclosing for other states. More yet, and not just give the notice, because no notice. So GDPR, you need to give notice, right? I said it's sometimes CCPA is more stringent, more strict than GDPR. This is the one example. You actually need to tell your consumers what you have done with their personal information for the past preceding 12 months. It's not just like, oh, here's all the data we're going to collect. Those are the purpose and who's going to share. Bye-bye. Now you had to go to your privacy lawyer every 12 months to actually detail them, what you specifically did in the past 12 months. Now, second rights is consumers now have this right called to request verifiable consumer requests, meaning they can come to you and say, hey, I want to know what data you collect about me and who you shared with for what purpose. All right, that's similar to GDPR. GDPR we call the data subjects rate, right? So, and then they also can request, say, hey, I don't like the way, the fact that you know where I live, what telephone number I have, and what kind of food I order. I want you to delete my information. You actually have to comply with it. And it's going to be a huge burden. So literally, the company need to, before January 1st, 2020, need to hire somebody or that designate a group to actually, be trained in how to verify the consumer, they are who they say they are, and then the protocols to give them, the information they need. So how do you do it? You through a toll-free telephone number, website address, and then you need to respond within 45 days. 45 days. Is that a lot? It's more than 15 days more than what you have under GDPR. It's 30 days. Okay, so it's the good things to have to do business in California, right? You got 15 more days. All right, so those are the details. But for this, it's going to be a huge burden. You need to know that the Attorney General is still figuring out the procedure process. For example, how to verify consumers, right? And how actually, the logistic in within to provide a response within 45 days. They are working on it more, so you need to kind of hold your inquisitive horse and just wait for that information. But this provision, has drawn quite a lot of criticism because, of course, legal scholars say, well, you need to verify consumer identity, therefore you had to actually collect more personal information, right? So you weigh the benefits and burden, I don't know which weighs more anymore. Then of course, you have to follow the deletion request. There are some exceptions there. Now, the third requirement, opt-in and opt-out. Do we know what opt-in and opt-out is? Opting out. Okay, I won't go through that. Now, sales of information. What sales doesn't mean sales, right? Sales mean a lot of other things. Sales adult information, you need to have opt-out. So GDPR, we have like what? Opt-in, right? So here we at least have opt-out. But then, you need to conspicuously have a link on your homepage titled, "Do not sell my personal information." So imagine January 1st, 2020. I'm sorry, I'm getting excited. Everybody's going to get a revised privacy policy from, whatever company or including yourself. And then in our privacy policy is going to be a very conspicuous. Well, how do we lawyers do with conspicuous? We're just going to capitalize and bold it, right? It's like, this disclaimer in a contract and saying, "Do not sell my personal information." Well, this kind of excites me. Right. Now for minors, then you need to opt in because, they're minors. They don't know what they want, so requirements are more strict. Financial incentives. Wow, it sounds easy, right? Here, this, give headaches to a lot of companies with like those royalty programs and all this, good stuff that consumers want. So it's kind of right. Also restrictions as well, saying, well, you can do financial incentives, but you need to be not just unjust, unreasonable, coercive, or the legally term. And if you want to induce a consumer into your financial incentive program, you need to obtain opt-in consent, okay? You just can't say, oh, I'm offering some benefits. Why do I need to even get your opt-in consent to offer you the benefits in the first place? But now you do. Vendors, I mentioned earlier, right? Service providers, if you are servicing a covered entity, then you are covered. Not all business vendors are service providers covered by CCPA. Give you an example. If you have a vendor, catering vendor, coming and give you chicken salad and during the CLE program, they're not collecting any personal information. They're vendors, but they're not coming under CCPA. And the vendors need to comply with depletion request, deletion request. And they are, independently liable under the Act, provided you, the business, did not know or had a reason to know they are, violating CCPA, okay? They're gonna serve their own jail time. Now, second last requirement, anti-discrimination. It appears to be innocent, right? Discrimination, you're like, oh, we don't intend to discriminate. But oftentimes you got sued even when you don't intend to discriminate. So it basically says you cannot charge consumer different rates, offering different services just because they are exercising their CCPA rights. Of course, then you got an exception there, and that exception is highly controversial. I'm gonna save your headache, by not going into it. Just because the how it's worded, a lot of articles written on that saying, well, it doesn't make sense to look at the the level of quality in relation to the value provided by the consumer, in the consumer's eye. Those who are interested, we can talk separately, but that's a separate jar of worms. We don't have time to go there. Now, last requirement, training. You need your training and need to document the training attendees. All right. Now, last section, strategies for compliance. I think for that 3 privacy lawyers here, I'll probably mean more to you. Key strategy considerations, planning for CCPA compliance. And also you need to assess risk and limiting potential liability, right? We got a kind of 11 months to go. Now, data mapping and inventory. It's a very fancy term now for privacy lawyer, data mapping. What does it mean? It means track what data, personal data, you're collected, okay? Label them, and then trace them, where the data goes, who that's going to be shared, subject to what contract, etc. Now, data mapping and inventory, if you are a GDPR lawyer, you probably have done that. And what's the difference here? The difference is under CCPA, it's not mandatory, it's not explicit requirement for you to do data mapping, but we think it's beneficial for you to do data mapping such that when you are responding to verifiable consumer requests, and then, trying to do your 12 months disclosure, it's more convenient for you. Otherwise, you will be like, hey, calling your IT, where's my data? Where's my California PI? They wouldn't be able to tell you. And then guess who's going to be in trouble? Not them, all right? All right, so data mapping. Yeah, so protocols for responding to personal information requests. It could be huge. I have helped U.S. companies in GDPR data subject matter request context, and it appears we don't have that tradition in the U.S. It's a new thing, and we basically don't know what to do, right? But in the GDPR context, there kind of established guidelines and best practices on how to actually establish a program, written procedure for your staff to get on a once from the date they receive a request to the 45 days window, right? The thing they need to do, how they should interface with the consumer, etc. Everything should be follow the same protocol to make sure.
Does the statute spell out exactly when you respond to the customer that or consumer that asks, what do you have on me? Does the statute spell out exactly how you provide that answer? For instance, is it acceptable to send back a form and say, we have your name, rank, serial number, and social security number, and where you eat, or your address, or things along those lines? Or do you actually have to provide more detailed information? We have your address and we have that address listed as X, and then provide the address.
So it's a good question. The answer is AG is still thinking about it. There are going to be, opinions or amendments soon on the detailed procedure. That's actually a very burning question for a lot of companies. And one U.S. company I've helped previously work with, they already have received such data request. Okay. I don't know where they get the idea. They probably get the idea from GDPR because CCPA is not effective yet. And they're asking us, what do they do? What do they do? We already have received a request asking for their personal information. Yeah. So, but, as I said earlier, if you have done GDPR data subject request, there's a, I think UK, the ICO has like established very thick guidebook on how to, request to data subject demands. And then we're going to wait for AG to come up with more guidelines. All right. Opting out DAO. So you actually need to have a protocol for processing opting opt-out, okay? Now, it's not just as easy. You send an email, and then you say, hey, click here to opt out, and then they opt out. And that opt-out action need to go to some database, separate database that you track, stored in-house to track, who at one time opt out what, okay? As for one, to make sure you actually, complying with the opt-out rules. Second is to make sure you actually have a documentary evidence to show that, you were implementing it. Now, we talked about earlier, the private cause of action, right, only applies in what? Data breach context. And what's data breach under CCPA? It's either unencrypted or unredacted personal information being compromised, right? So one strategy, of course, to reduce liability on a data breach, in data breach is what? To encrypt and to redact. So, of course, encryption comes with cost. I'm a computer science major. I used to do security consulting. Encryption is expensive. But if you can encrypt yourself out of legal liability, you might be able to persuade your IT people to do it. Also, when you encrypt, you want to keep your decryption key separate, right? You don't want to lock the door and then hand the key next to the doorknob. It's common sense. Right. Now, vendor agreement certificates. We talked about earlier, service providers may be independently liable under CCPA, right? Now, there are also requirement that, when you give your data to a vendor for processing, and the data subject, that's GDPR, a consumer requests you to delete data, you actually need to go to that vendor, say, hey, you need to delete that copy of data as well. So, this whole chain need to work smoothly. And then you make sure, I do a lot of technology transactions. Oftentimes, in a kind of a typical day-to-day transaction, either be your host data, you give your data to a cloud service provider. Nowadays, almost every company does that, right? Every company, in a good size, your at least employee data, HR data, you're going to hand over to certain cloud service providers to host, just to store there, or to the more extent you are, actively licensing the data, including personal data, to a third party to process or to commercialize and monetize. Those things you need to be careful. CCPA has requirements, and you need to put those contractual provisions there. Anti-discrimination. So you want to make sure, this is privacy by design concept in the product design architecture phase. You want to make sure no such discrimination rules are embedded. It's such a kind of a easy concept, right? But sometimes some businesses are doing it. You heard about some app and they're really fined for age discrimination, right? They charge different rates based on the age of the individual. I won't mention that company's name, but the news just came out yesterday or today. You should go to find that out. Training. So training document, but most importantly, this person or the group of person who's dealing with consumer verifiable consumer requests need to be trained, because you have 45 days. You want to make sure that person know what to do, since day one, and you don't want that person say the wrong things. And then if that person say the wrong things on the phone call or the email, guess what? What are you gonna get? Lawsuits, private cause of action. It could be anything. It could be like, oh, you violated anti-discrimination. You're discriminating because I'm exercising my rights. This is a big kind of a hole that could potentially lead to that path you don't want to go. And also, probably more a Kim question. Does CCPA authorize a class action lawsuit? So it is silent, but private cause of action can lead to class action, right? If it's a mass of consumers subject to the same kind of cause and fit all that class action requirement, so it's possible. So a lot of money is involved. Now, revising consumer notice and disclosures. So Californians' right to know. As I said earlier, I'm getting excited to think about January 1st, or actually let's say December 31st. This year, you're going to receive all the revised privacy policy, and then you're going to say, oh, Californians' rights to know. They actually had to disclose, in a privacy policy. As a California, you have a right to know this, to know that, right. So basically, you're going to have a GDPR compliant privacy policy. On top of that, you're going to have a California CCPA compliant privacy policy. And how do we do on time? Ooh, we got 15 minutes. So I run through some of the provisions quickly. There are a lot of more complications. I guess we're going to save the rest of our time for your questions.
So it seems like there would be some Commerce Clause issues here in regard to its application to non-California. So has anyone started raising these, like in public forums?
Yeah, in some of the AG meetings or scholarly type articles, that has been raised. So either the constitutional ground of challenge, either under Commerce Clause or under even First Amendment, it has implications there. But I think the slides did not cover it. There are exemptions under CCPA. In terms of what type of entities are subject to, as a covered entities. So if you are a financial institute subject to, say, GLBA, right, or subject to HIPAA, and those data are exempt, okay, from the CCPA. But that exemption is not absolute. There are exceptions to that exemption. For example, if you are a financial institute, you're subject to GDPR, GLBA, you cannot just walk away. It's like, wow, I'm so glad that now, we're subject to GLBA and then we don't have to think about CCPA. That's wrong because what? Any guess? Employees, right. That's because you do not just have GLBA data. Even your financial institute, you will have non-GLBA data. If that's not subject to GLBA, then it's going to come under CCPA. And second reason you probably want to know is that if you have personal data that's going to be subject to California data breach notification law, and that's going to come under CCPA as well in terms of data breach, okay, notification.
And then, so for vendors though, do they have the same? Are they subject to the same prerequisites before the CCPA will apply?
Oh, like that's $25 million. I don't think so. The vendor come into play when they are servicing a covered entity already under the covered entity that meet those those numbers.
So any vendor, no matter the size, servicing a covered entity, subject. So
Right.
It could be like a teeny vendor.
Right. So if you are a service vendor, you have to look your customer list, right? If 90% of your customers are like not even California company, the companies could come under CCPA, then you have to really alter your practice, Other than price policy, just vendor contracts, there's a lot of work to do because in my day-to-day practice, not just on CCPA ground, I heard we signed like 20,000 contracts last year and we forgot about this and we cannot go back and then redo all the contracts. What do we do? So it's a kind of a similar thing for CCPA now. You have to put the provision there saying if I give you California personal information, when the contract expires or terminates, you need to delete, return everything and certify. Okay, provide me with certification, and that's kind of what the black and white law requires. Also, the right to delete. If your customer come to you request to delete their personal information, then you have to go to the vendor. So the contract should say, whenever I get that information, you should provide a collaboration and fulfill those demands for you.
And then you were talking about this private right of action. It applies for instances of data breach.
Only.
Yeah.
Okay. So for an anti-discrimination, for violation of the anti-discrimination provision, there's no private right of action.
No, according, yeah.
God. And absolutely right. That's how I read the statute as well.
Yeah.
But let me just point out something, because right now I know everyone is focused on, and you need to be focused on, compliance and how you get yourself ready for compliance. I have, though, in the next year, what I need to think about is how to defend against creative ways that the plaintiff's class action bar, and I hope, although you're always welcome here, that I'm not giving away secrets to the plaintiff's class action bar, but to think about ways to limit potential liability. Because those of us in California know we have this wonderfully broad statute, the UCL 7200, and I have seen cases where plaintiffs have been able to bring UCLA claims, or UCL claims, nothing UCLA, sports. It's basketball season, forgive me. To bring UCL claims under the unlawful prong, alleging the violation of a statute for which there is within the statute no private right of action. Those of you in the room who have had to deal with litigation like this, there's authority all over the place, Farm Fresh Salmon, Stop Youth Addiction, and a bunch of other cases. But true, the circumstances under which someone can bring a private right of action under the statute, that's the name of the count, is limited. But query whether violations of other provisions, a whole bunch of consumers saying, I keep calling ABC company, I keep asking them for information, they're not getting back to me in 45 days. you don't have a private right of action for that, am I right? At least in terms of how the statute is written. So, of course, everyone wants to comply with all provisions of the statute, but there may be reasons to believe that someone may creatively try to bring a claim, not a claim under the statute, for violations of the statute for which there's not a private right of action. I think you'd ask the question about class actions. My view is if the statute doesn't say you may not bring a class action, you can bring a class action. And we know that even if the statute says you may not bring a class action, someone still might be able to do that. And then one thing I was thinking about, and I'll tell you, I probably should pull up the statute and do a search to find out if the word arbitrate or arbitration appears anywhere in the statute. I didn't. But a question to think about. What if your contract with a consumer contains an arbitration provision or a class waiver provision? Will someone invoke PAGA or some other public policy, court-made public policy exception to say that you can't force consumers to arbitrate claims brought under the statute? So that's sort of like not the final frontier, but that's the next frontier once, the statute is finally enacted and compliance begins. And so those are things to not necessarily fret about now, but to think about when it comes to, again, not the AG compliance notices that come in imposing fines, but when the creative lawsuits start coming across the transom.
And yeah, not to scare you, you think this is bad, right? State level CCPA. In the U.S., the city level actually started their privacy regulation. All right, Chicago. Do we have Chicago people here? Not in this room. Chicago is the first U.S. city that has been considering a privacy statute full-blown, okay? And San Francisco, my resident town, now has just, we have just approved the privacy first policy, which will next enable the government actually to adopt a full-blown privacy statute. So, you think you have a 50-something state potentially privacy law to think about, now you're going to have municipal level, city level to think about. So, in the end, in the future, we were going to have a uniform federal level. That's probably be better off to have that. But some question, that's never going to happen, because in the U.S. we take a different approach to privacy, compared to in the EU, where GDPR is largely motivated by what this privacy right is a fundamental right, human right, to people. Therefore, we have, you residents have a right to be forgotten, right to request data subject and all that things, and non-EU residents don't. In the U.S., privacy concept largely motivated by this tension between what the government and the people. All right, government should be protected, or should be precluded from intruding each individual private life. So in a way, partially because that we don't have a comprehensive data protection law, but now with state level, municipal level kind of a statutory effort, we had to kind of ask the question, what's next and what's the best for companies. I see. Final
question.
Yeah.
It's just, so let's say we're dealing with a non-profit that collects donations. Is that?
Non-profit is out. The statute.
Yeah, so it's explicitly excluded. What if it's like a university or something like that? Is that excluded as well?
Yeah, non-profit is exempt from the statute.
So thank you for the sprint through the statute. It's very good. One of the things that you mentioned was an issue that came up with GDPR 2, and that is whether you're going to extend the rights under this California statute to people across the country, rather than try to just offer the rights to California. And So one of the issues that we see is that when you put rights into your privacy statement, they become enforceable under for example, the Federal Trade Commission Act. The FTC can enforce them because now you've made promises in your privacy statement.
Mm-hmm.
And the state attorney generals can enforce them as well because they have little FTC acts. So you don't necessarily import the whole statute, but you do have to keep in mind that if you provide rights that you have to provide to California residents in your privacy statement, which you would have to do, if you state those as broadly applicable to everybody, you just created enforceable rights across the country.
Right. So what's the best? So the question is, for all these unique rights we have discussed today that's specific to California residents, if we blindly include them in our privacy policy, in a way we can extend such rights to non-California residents. Is that the best practice to go? Because you're creating like more contractual obligation. Right. So FTC, under FTC Act, the government, the federal prosecutor can go after you if you kind of like fraudulently or made a misrepresentation in your privacy policy. Okay, it's not specific to any state law or statutes. So you have to say what you have to implement, do what you say, and mean what you say, and say what you mean. Right? Yeah, I got that right. So what's the best practice? Now, the practical solution to that is in your privacy policy, you do not say, oh, all the U.S. states residents have this. You're gonna say to the extent any applicable law requires, or you're gonna just say for consumers who reside in California, okay, and dedicate a section that's gonna be just for California for CCPA purpose. That way, you kind of like narrow your premise a little bit. All right, more questions? Oh, we got another one. Government entities, huh? Well, it did not say private entities. So far, the exclusion is nonprofit. If you don't make any money at all, nonprofit, you have this nonprofit status, right? The registrations and whatnot. And then any other company, yeah, I think that includes the government. If you can satisfy the 25 million, that's a high bar. I know what the other information.
Well, I think it would be difficult, I think, to remember what the second one is. The first one is a revenue threshold, right?
Right. The second one is
the government's going to meet the revenue threshold, given the definition of revenue. The last one was 50% of your revenue is generated through the sale of personal information. I don't think a government entity, by definition, will meet that one.
Well, the second one is 50. You are collecting 50,000 consumer record. That the government probably would be. Yeah, some of the like a retirement, I think community, the government entity probably gonna have that, but yeah.
Actually, on that prong, it talks about alone or in combination. To what extent does that apply? I mean, do you have to have 50,000, or you and whoever you're sharing it with, you have 25, they have 25,000?
When you read the statute now, of course, we don't know. But if you do the actual counting, I think, alone is easy, right? In combination, say, if you have, in combination with another third party, if you have like subset of PI, and then another party has like another subset of PI somehow not complete, and then you might be, yeah. I don't know the detailed math, but if you can figure out creative ways to get yourself out of the 50K, then good luck to you. But I suspect you probably don't have to rely on the second prong. the revenue problem probably easier for the enforcers to track.
Well, no, I mean, this could trip up small businesses.
Companies, right. Right.
Someone who's selling on Amazon, has
Mhm.
a ton of this stuff, that
Right.
in combination with, you can trip that up.
Right.
So, to what extent that in combination problem gets people tripped up?
Right. We don't know details yet.
Yeah, I mean, and the thing is, I mean, it's like I can remember there's been multiple times, you know, you're trying to write appellate briefs. I know everyone knows this, and you don't have any construction of the statute. I mean, yeah, so this really is just a blank slate. And because California is the first, we won't even be able, when we're trying to figure out, you know, the meaning of these somewhat, maybe more than somewhat ambiguous provisions, you know, looking at what other analogous state laws, state courts have said about other state laws as interpretive guidance.
Yeah, we're gonna spend the next couple of years litigating it if the statute is not knocked down, you know, under Constitution ground. So I guess, you know, the game's gonna go on. Next year, if you're here, if I'm here, we're gonna continue the discussion. And thank you so much for your time.
Yeah, and let me just say one thing, because I was talking to somebody, so there's no confusion. You know, what they've tried to do, I think, is to avoid certain federal preemption issues that they were going to run into. You know, for instance, HIPAA